Now we will hear from the only attorney with False Claims Act experience specific to defense contracting and cybersecurity. That's attorney Gregory Thyberg. As you may know, the DoD has long aimed to ensure contractors in the DIB comply with cybersecurity minimums as prescribed in DFARS Clause 7012. Safeguarding covered defense information and cyber incident reporting. To further ensure that companies are honest in their reporting of compliance with contractual cybersecurity requirements, the federal government instituted the CMMC program, and the DOJ doubled down with the Civic Cyber Fraud Initiative last October. The initiative seeks to utilize the False Claims Act to pursue fraud cases in the DIB. One such case, specific to DFARS cybersecurity compliance, was underway before the initiative had begun and recently concluded. In 2015, Brian Marcus sued his former employer, Aerojet Rocketdyne Holdings Incorporated, under the False Claims Act. Marcus, the company's chief information security officer, refused to sign a document claiming Aerojet Rocketdyne had achieved compliance, instead writing an internal memo with concerns that they hadn't met compliance requirements. He was laid off soon after that. At CMMCCon 2021, Brian Marcus and his attorney, Gregory Thyberg, addressed the case and the importance of compliance for contractors in the DIB. The outcome of the case was disclosed in early July, with Aerojet Rocketdyne agreeing to pay $9 million to resolve the case. We invited Gregory back to discuss with Carl Herberger, CyberSheath Vice President of Security, the details of the case and what's at stake for DIB contractors that don't meet compliance.
Thank you, Julie. That was a wonderful introduction. I really appreciate that. Welcome, everybody, to what I think is going to be one of the best sessions at CMMCCon. A session that's talking about the False Claims Act and revolving around a most recent summary judgment that Greg and his firm has been lead on. And I'm very excited to have a conversation with you, Greg. Thank you, and welcome again to CMMCCon 2022.
Well, thank you. It's a pleasure to be here again.
Wonderful. Listen, what I want to do in this conversation is get all of our listeners up to speed on the history of this case, and then we'll go into this final judgment that you have just been part of. And then I'd like to spend some time thinking about the lessons that have been learned, I think, throughout the case, and how we should all be thinking about things moving forward from that. And I think this whistleblower concept and construct under DFARS is they learned a lot of lessons through you. And I think, Greg, actually, frankly, you're a vanguard, and a harbinger at the same time. So I'm very excited to be talking to you today. So let's go with the history. How long you've been involved in the case? How did it originate? Maybe walk us through. I know you were at CMMCCon last year where we went through a lot of this, but just give us a little pithy overview of how we got to where we are.
Okay, well, the case goes back actually to 2015. We're dealing now with almost 7 years. Part of the delay is COVID, and part of the cases, these false claims cases, when they're filed, they're under seal. The government's investigating for a few years before the case goes forward. Right. The case was filed in October 2015, and at the time the case was filed, they had the NASA FARS cybersecurity regulations have been out since 2011, and really the DFARS clause that we talk about was really relatively new as it went in the end of 2013.
That's right.
And this was really the first case. My client Brian Marcus came to me and had concerns, had raised some issues about the compliance. Of course, led to him losing his job, and looking at what he was telling me, I think there's a false claims issue here, because in these contracts, there's requirements that they meet these certain minimum cybersecurity controls and standards if you're going to be handling the government sensitive information. So it really started there. Our case is the first case really to apply the False Claims Act to cybersecurity. Just for the background of the people in the seminar, the False Claims Act actually goes back to the Civil War.
Wow.
Back in the Civil War, the government was doing first time really doing a lot of purchasing and fighting the Civil War, and people selling to the government were taking advantage of that, providing government defective meat, crates that were supposed to have rifles that had straw, this sort of thing. And so the government, way back in the 1860s, was the beginning of the False Claims Act. And the modern era really started in the 1980s, 1986, they did revise the False Claims Act, kind of revived it for modern times. And really, it's to go after fraud when people or contractors contract with the government and they make false statements or don't give the government what they paid for. So we're using something from the Civil War now to take on the cybersecurity battle of the 21st century.
It's amazing. What you're really teaching me is that it may have been one of the first supply chain regulations that we've had in place in the country. If you think about it, it's really focused on contracting with the U.S. government.
Right. I mean, a lot of the cases before this deal, I mean, it's been a big thing in healthcare. That's where really most of the cases have been. There's obviously some cases involved in the defense industry, but this is really the first one that took it into the realm of these cybersecurity regulations, which interestingly enough, after I filed my case, a lot of and it got exposed to the public after the motion to dismiss, it became public. A lot of major law firms had actually been warning their clients and writing about how the False Claims Act was a potential issue for defense contractors who were, with their computer networks, that this was a potential issue if they weren't compliant, if they were misleading the government. So
it's amazing. So you had your client who was in charge of cybersecurity for Rocketdyne Aerojet, and he believed that there was a erroneous claim against the Defense Federal Acquisition Regulation, a DFARS clause around their state of cybersecurity. And as a result of that contention of opinion, he no longer had gainful employment at Rocketdyne, and that was as a result of really his opinion on that position. That's essentially the situation that took place right back in 2015.
Actually, he came to me, as many people do. You're in a job and you speak up about some things, you lose your job, and you go to an employment lawyer, and started telling me about these different regulations. And then from my experience handling false claims cases, he came with basically what we call a wrongful termination case. And as I looked at it, I said, well, I think there's a false claims case here. And that's really where it got started.
Amazing. So 2015, and then I know there was a lot of motions and a lot of activity between 2015 and 2022. So bring us up to speed. So that was the claim that the company had done something erroneous against the rule. Tell me what happened in this year.
Okay, so as I indicated, the case remained under seal, from 2015, literally up to around June of 2018. During this time period, the government investigates these cases, and our complaint, they investigated the allegations. And interesting thing was the government decided that the government usually can intervene in a case, which means the government takes it on. Or if the government doesn't intervene, then the relator, that's the person called, like Mr. Marcus, bringing the case, and their counsel can bring the case on their own. In this case, the government decided not to intervene. I think, again, because I think these were some new regulations. There were some issues with compliance with a number of contractors. And I think also some of the things that we developed later, I just don't think the government really was aware of. But they didn't intervene. And then, so the next thing that comes up is we had to win a motion to dismiss. And that's where a lot of these false claims cases get bounced out if the government doesn't intervene in the case. Literally, cases where the government doesn't intervene, about only 30% of them survive the motion stage. Mm-hmm. This case, the argument Aerojet had was, well, the government was aware of some of these problems with their company, and they were aware in the defense industry that there were some issues with things which were true, but they kept contracting with us. So they were saying it wasn't, you have to prove it's material, that it would affect the government's decision to contract with you. So the argument was, well, the government's still giving us contracts. They know we're not perfect. They know we have some issues. It really didn't matter, that you can't prove that this would have affected the government's decision process. And so the big news was at the motion dismiss stage, was that we presented our, what was in our complaint. And the judge looked at that and said, if they can prove these things, it was the first time a court ruled that compliance with cybersecurity regulations could be material, which is a big deal in a false claims case, because most places, if they get thrown out, they get thrown out on the issue. It wasn't material to the government. Literally, it didn't matter to the government whether they were.
Wow. So now is this precedent setting then in
Yes,
terms
that
of
was it. Yeah, it was that motion to dismiss probably was bigger really than our summary judgment. Both sides filed for summary judgment, and neither side got summary judgment. But the motion to dismiss was what really set the legal precedent that if you don't comply with cybersecurity, it can be material, and it's an issue then for the jury as to whether your non-compliance and representations to the government constituted a false claim.
It's funny. All of this reminds me of, if you've lived long enough, I know you have too, Greg. This reminds me a lot of like safety regulations and nutritional information regulations and production facility. Remember before airbags and before backup cameras and all these things, the car companies used to make a case and producers would make a case. Well, people are buying it. They're happy with it, and
Right.
we tell them the risks and so forth. And today it's a totally different world. And I think thanks to your efforts, yours and Brian Marcus's efforts and so forth, I think you're really leading a better world for us. But it is a different world. There's no doubt about it. I think this is the point on CMMC Con that I would really like to bring out is how you've created a precedent. And I think, honestly, in the world of cybersecurity, it's so needed. And that's my bias towards it. I believe that the cybersecurity is endemic into defense. And I'd love to understand how this moved into a summary judgment and what lessons were learned from you throughout it. But I just want to applaud you. A lot of the world is run by unsung heroes. And I think that you've done some heroic work here. I know, talking with you, to get from 2015 to that point where you got over the motion to dismiss, and then from there to the summary judgment, I know that there were a lot of naysayers, and I know that you had to build an army and a case, and at the end you had to believe in it. So it reminds me of the reasons why people go into law, and I want to thank you for that.
Oh, well, thank you for acknowledging that. It really was interesting and a significant case. I mean, I was a sole practitioner really going against one of the largest, most prominent law firms in the world really on this case. And really until the end, when I brought another law firm in, we actually had to go to trial. It was, I was a sole practitioner doing this, but I felt it was such an important case. When the government doesn't intervene, they sort of like the relator just to kind of go away,
Right.
And then basically they told me when they didn't intervene, they're saying, well, how are you going to carry it forward? Sort of like, you're a sole practitioner, you're going to go against this top law firm. But it was a good case, and it was too important a case because of the national security implications. And I think as a result of this, the government rarely admits exactly what reasons they do things. I think we did move the government because after this case was filed, as you know, there's been more revisions to the cybersecurity regulations. There's the CMMC standards that have been introduced. And now this cyber fraud initiative that they announced last October, the government's saying, you know what, we're going to use the False Claims Act to go after contractors if they're not telling us the truth and they have serious vulnerabilities. So
right, there's a whole new office in the FBI, right? My understanding from the FBI through their public releases is that they've created a new office dedicated to bringing False Claims Act cases to judgment. Is that and I have to believe that you were a big piece of the energy on that.
Yeah, I mean, I was just reading, they came out with a report in July as to what they're doing. I mean, cybersecurity across the entire government now is something that's such a high priority. And one of the things they cite is the False Claims Act, and they're training more attorneys and prosecutors and all these people to have the teams available to pursue these sorts of cases. And so when our case, I mean, it was really a case where they were really watching. We didn't actually get a judgment. We actually ended up getting to trial and actually settling in the trial. But it's still a state, it's still a statement that, here a company saw exposure. We got it all the way to a trial. It was going to be really at the end a jury issue as to, what are the damages to the government. That's one of the interesting things in these cybersecurity cases, because it's kind of like proving what was taken. Sometimes you don't know what was taken. How badly was the government damaged? One of the arguments was, well, you can't prove anything was taken or who got it, but that's kind of like saying the revenge porn case. If somebody puts something on the internet, you can't prove anybody saw it. It's one of the sort of difficult wrinkles of this sort of a case. But
so, Greg, help me understand the strategy on behalf of Rocketdyne Aerojet. It seems to me like they were just trying to run the clock on this case, and they were really not forthcoming or even willing to negotiate a settlement until it was obvious that they had lost it and wanted to run the clock. Is that fair assessment? What's your assessment of why this went 7 years, and why would they settle at trial if they didn't believe in themselves?
Well, I think that first of all, I don't think these cases settle really until you get to a summary judgment. That's most of these cases, whether it's this case or another case, the summary judgment is something a defense firm always likes to do in the case. It's a chance to go to the judge and to argue and to not even get it in front of a jury. So I don't think any serious settlement negotiations were going to happen until that summary judgment happened. And of course, those usually happen late in the game. It happened, usually near the end of the case, after all the close of all the discovery and everything is done. So I think that the delay is really, we tried earlier to try to solve it, but sometimes to do a settlement, but sometimes it's just too early. You really have to get the witnesses and get all the documents and review everything, and sides have to assess their risk. And I'm sure, of course, their settlement, they still take the position that they didn't do anything wrong. That's the way it always is in these settlements. But we believe we had strong points to make, a strong case to bring to the jury. You never know what a jury is going to do, but it's just kind of the nature of these cases that they don't usually settle until the summary judgment has been completed. In this case, it actually got all the way to a trial, which is even more rare. But I think we got to trial. It was very serious. I think both sides saw issues. You never know what a jury's going to do, and that was the sort of the pressure point to get this thing settled. So
yeah, right. Wonderful, Greg. It almost sounds like a Hollywood kind of case. Tell me about this. What can you tell us? I guess disclose with regard to the judgment. I think some of it's out there in press. How is one to look at the course of action, Chad? What was the actual judgment, and do you think it was worth it, the time, the effort, and so forth?
Well, it's not actually a judgment. It's a settlement.
Settlement, right.
It was, it was $9 million with $2.61 million going to Mr. Marcus. One of the things in this case, it could have been larger, the case, but in this summary judgment, there were some issues with narrowing down some of the contracts. And that's also why the settlement took longer, because it's kind of an issue of how many contracts were going to be in the case, what was the total scope of the damages. And unfortunately, in this case, we had a $1.8 billion, $2 billion contract that the judge, which is actually probably the strongest claim we had in the case, that the judge excluded because, again, these cases are filed under seal, and we filed the case on October 28th, 2015, or 29th, and the government awarded the contract on November 1st. And although all the negotiations had clearly occurred before, obviously, November 1st, the judge took the position, well, because that contract got awarded 3 days after your complaint was filed, that we couldn't pursue that contract. So there were a lot of technicalities in which case, of course, and there were some of these contracts, some of them older ones, some ones didn't have the DFARS clause in it. And some, so, you know, when you talk about the settlement, the summary judgment helped kind of narrow down which contracts were viable, which ones had the clause. And, you know, it narrowed down, and that really allowed also the parties to kind of know what's the full range, Aerojet to know what's the full range of their risk if they lose a trial, and for us to understand maybe what's the full range of what we can get if we win a trial. So in this case, the judge really didn't answer a lot of those questions really until we almost got to the eve of trial, before we really had a clear understanding of the way the judge was viewing the case and what contracts he was going to allow us to put in front of the jury and which ones weren't going to go in front of the jury.
It seems to me that just numerically, the problem is getting much bigger. So that's the first piece. And then the challenge that you have with being able to document this settlement and this whole process that you've been through, Greg, helps document, I think, very poignantly, a very big risk that companies take to non-compliance that I think also is not obvious to them. In other words, I think they understand the law and the rules that the government can impose upon them and judge against them and keep them from contracting. But I don't think they see the whistleblower challenge, really. Said simply, and I'd love you to opine on this, I believe that there are many legions of non-compliance. In fact, we are releasing at this conference data that we've taken, which I think nobody else has. And that's a huge survey that we've done, self-reporting from primes and subs, that roughly 50% of the companies that are already contracting with the government are in a non-compliant state. I'd love for you to opine on what you think the future holds for the False Claims Act on this set of laws, on these sets of laws, and the future of whistleblowers. We saw today, or over the last 24 hours, a big whistleblower come out in a Twitter case, for example. Now, I know that that's not associated with DFARS and so forth, but you can start to see really prominent whistleblowing going on. And I don't think that's really being accounted for, especially in the defense industrial base.
Yeah, I think that, I mean, you're absolutely right. I mean, when this case started back in 2015, it was something new. There were different government contracting officers. Some were familiar with it and really asking questions, and some it was something new. But, you know, as time has evolved, the government's now, you know, really with the cyber fraud initiative and just statements they made it very clear that, you know, they expect compliance with these regulations. One of the arguments that was made in the Aerojet case was, well, you know, our contracts really provide the propulsion systems and the rockets. It's not a cybersecurity or you know, data storage type contract. And the government's made very clear that when you contract with the government and you sign on, that they're expecting you to be compliant with these clauses. And you know, for these companies, I mean, they're struggling. And I think I said last year, the issue is not just non-compliance, but it's what you're saying to the government. So one way to protect yourself is to be transparent. To make it cybersecurity a priority. There's always a tension between sort of the accounting people, the people looking for profitability, because nobody wants to have to spend money on cybersecurity. Just like in my house, I don't want to have to spend money on the gardener, but if I don't have a gardener, there's consequences. And so that tension runs, and sometimes the people in the executive part of the company don't understand cybersecurity, the importance. It's not something where you can just like cut costs or ignore it. You got to make sure that you're dealing with it. And if you don't, you will get people, your cybersecurity people who are trying to do their job, are patriotic, trying to protect national security. And eventually they get frustrated and they're going to come to somebody like me. And that's a big danger for these companies. They have forward.
That's how I see it. And I think in this world where maybe I see defense, obviously the defense, we just passed nearly $1 trillion budget in the US. I don't think defense spending is on the up, but the economy is obviously on a teetering effect. And I could see situations whereby people are let go or furloughed, or there's tension between more people, less people doing more, that whistleblowing becomes a bigger and bigger concern as people fight for retribution or look at revealing policies or procedures that are like the Twitter case,
Right.
where they feel like there was an egregious action. The Twitter case is very interesting to me because the fellow has been gone from Twitter for
Right.
years. I don't know how that's going to flow out there, but the idea that you may have contracted years ago and may have had somebody responsible during that time blow a whistle on you, maybe you can talk even through that so that there's some risk, essentially what you have done from the past.
Right. Well, the statute can go back 6 years or more on the False Claims Act, and you're right. I mean, beyond the DFARS and NASFARS clause, I mean, this is something that's going to be an issue whether you're in cybersecurity in a hospital protecting patient records or anything where the government's expecting you to be protecting information. There's now clauses and regulations and things that have to be addressed.
So I get the question all the time for people to say, "Come on, Carl, we clean houses on a military installation. What do I need to do about cybersecurity?" Or and I feel like at Cybersheath often that we are almost like an ombudsman for the government in trying to explain how the program was designed and set up and so forth, and that really it's not a question of whether or not you like it or you don't like it. You contracted for the actual compliance, right? As part of the condition of contracting, you've taken on the obligation. So there's nobody to blame because we hear this, we're a small company, we can't afford it. You name the reason why they can't get this done, we've heard it along the way. But I always come back to these are things that when you saw the dollars, you decided to run towards, but when you realize the conditions, you now have an objection to it. And that's a very dangerous situation to put yourself into, is what I'm gathering. I believe that as we go forward, there's a bifurcation of risk that is maybe equally as large on the whistleblowing, non-compliant personality or culture than there is on the problem associated with the government suggesting that you are doing something wrong or maybe fine you, something along those lines, right? I think it's much less likely that if you're trying to do something correct, that the government's going to come down hard on you than you have a problem with a whistleblower and all of those situations with whistleblowers. I'd love to get your feelings too on the whistleblowing, how far it goes. Let's suppose I'm a prime, like for example, Mr. Marcus represented a prime largely, but if he knew that this affected a bunch of subs, or maybe subs had a problem with the prime fulfillment, does it flow down like that, or is it each? How does that work?
Well, these clauses do flow down. I mean, these prime contracts, like in our case, there were a lot of contracts with Missile Defense Agency, and all those contracts, they flow down these DFARS requirements. And so the prime contractors are responsible for making sure that their subs are complying, and the subs are responsible when they take on a contract to be complying with these DFARS and NASFARS clauses that are incorporated. And yeah, I mean, they don't even have to work for the subcontractor. Someone who works for a prime contractor, if they're aware a subcontractor is doing something, well, first of all, they should be telling a subcontractor to do it right. But I mean, if they're aware the subcontractor is entering lots of other contracts with the government and concealing things and not being honest, they can whistleblow on another company for that matter.
Right.
It's not just limited to the prime contractor. And really that is a risk. I think the whistleblower is a bigger risk because you mentioned all the thousands of these contracts. I remember you mentioned a number that have these DFARS clauses. I mean, there's obviously thousands of companies in the defense industrial base. The government's can't look at every single company. So you're probably much more likely to be caught by somebody inside your own company that becomes frustrated with what you're doing. Again, I can't emphasize enough that, one of the things that protects you is just to be honest. And I think the government wants to try to work with companies if they're not compliant, but they don't want to find out that the company's lost lots of information and they didn't realize it. One thing you mentioned about a small company is, a chain's only as strong as its weakest link. And some of these small companies, because of the nature of work they do, they're working with information that was developed by much larger companies, and the information's still lost. And we, of course, in an era where, a few clicks of a mouse and some extra effort, a bad actor can get billions of dollars in technology by putting a few hours of work in. That's a pretty good return. So we've definitely made the priority.
It makes so much sense too. And the idea that you have a security person that you paid to be responsible for security person tells you that you're not compliant with cybersecurity regulations, and that you somehow overlook it. It's, if you think about the analogous, it'd be like telling a financial officer that the way that they've added up the books is wrong, or the way that you tell a legal officer the way they're interpreting the law is wrong. I suppose you can do it, but it's really a risky situation for a business owner. What major
Heading on cybersecurity, I think it's penny wise and pound foolish, because exposures can be so great if you end up on the wrong side of a false claims case. This one for Aerojet, we obviously settled that one, but I'm sure the defense costs over the years were probably even a lot more expensive than what it cost them at the end of the day. So these things are expensive. Even if you hire lawyers and at the end of the day you're able to somehow prevail, these are very expensive things for companies, and they should really be thinking of the big picture.
Yeah, they settled with you for $9 million, but I can only imagine what the total cost was in terms of the whole endeavor for them. I know along the way. If you were to go to a bar and have a beer with a chief security officer, and you knew that they were associated with the defense industrial base, what would be a few of the recommendations that you would make to them, based upon the lessons you've learned in this case? What kind of pearls of wisdom could you impart?
I mean, to someone who's trying to comply, and I mean,
they're trying to do the right thing, and let's say they feel like they're doing the right thing, but are there things that you would still suggest take a look at the following, or think about this or that?
Well, I think the first thing is you want to have is honesty, transparency. You've got to be working with the government. That's the only way. It's like an inoculation of a vaccine. If you've told the government the worst things that the government could find out, then you don't have a problem. And the government wants to know. They want to work with I think, defense contractors, because they realize its challenges, particularly for smaller companies. And I think in a way the government can really assist. They don't want to find out later that they lost information. The thing is that this is all about protecting our men and women in combat, and the government wants to know. I think a lot of companies want to, there's a breach or there's a problem, and they think that they're trying to hide it or don't want the government to know that they had this vulnerability or whatever. But part of the issue is no matter how good your cybersecurity is, we all know that, with enough effort, anybody can have an incident. It's impossible to stop everybody. But the point of these things is to be able to detect early, to try to mitigate damage, to be able to know if information is lost, what's taken, so the government can do a damage assessment. And the government also want to have that code or that malware to know what was the vulnerability, so the government can warn other defense contractors. So I think the biggest mistake that can be made is this. I think with this whole veil of sort of secrecy that people have because they don't want to show that they weren't perfect, it can actually be very damaging.
It's funny.
I don't think the government's trying to get people, a company, whether you're making your best efforts, whether you're putting the resources in, whether you're working hard at it. And I don't think the they're not out to shut down or go after companies where they're really making a hard, good faith effort. It's the company that's, knowingly like, all right, we got problems, or we're still going to cut the budget or cut the staffing, or we're just going to allow this to go on.
Yeah, right. That makes perfect sense, Greg. It's funny. I mentioned the survey that we have completed and which Eric Noonan actually delivered as part of his address. And it was shocking to me when we asked the question about what's the motivation for you to be compliant with the DFARS. And of the available list, one of it was to be secure, especially secure against nation state actors that might be after defense industrial base entities. That was last on the list for the companies overall. The number one thing on the list was to make sure that they can continue to contract with the government. They wanted to make sure that their revenue stream was secure. The next piece on the list is they wanted to make sure they didn't get fined, right? That was the very next. So the idea that the altruism behind the laws of DFARS and the regulations around being truthful, which is the False Claim Act, those were far lower. The tenets of those ethics, right, were far lower in the response.
Well, people understand is like, I tell people, I have clients in many different contexts. They're upset about what the company's done this and the company's done that. And I said, a company is just a group of individuals. They don't have a conscience. They're not a person. They're trying to maximize value for stockholders or whatever. And there's maybe a lot of individual people within companies that maybe want to do the right thing. But, I think that's what you tend to get. And companies are, they're not really persons in that sense. And the bottom line is usually what prevails. But
that's right.
But it is a national security. I mean, that's why this has been such a gratifying case to move the ball further down the line toward helping incentivize companies to become compliant. I mean, obviously, as a false claims lawyer, I like to have cases to handle, but I mean, the bottom line is to have people comply and to protect our country. For people in your industry, there's good news and there's bad news. The good news is you're in a growth industry, and the bad news is you're in a growth industry. I mean, it's two sides of the coin. There's always going to be those cases out there, but we want to see companies improve. We want to see our defense technology protected.
Yeah, that's great. Listen, so I asked you about how you would consult with a security person, and I would love to get your opinion on two other constituent spaces out there. One is the small business owner that doesn't have a security person. In fact, he or she doesn't even really know, maybe they're trying to do the right thing. How would you counsel them on this? So maybe they're stricken to even tell people that they don't even understand what they don't understand, that they're afraid to, and there are many people, I believe, in that category. We have many companies, a lot of them are small manufacturers or small service providers. And the second is, I'm a whistleblower. I'm afraid, I should say, I'm thinking about whistleblowing. I know there's a big problem that I have before me. I'm afraid to whistleblow because I may lose my job, but there's nothing that's happening, and I know the company's totally non-compliant. How would you counsel those two different sets of folks?
Okay. Well, the small employer or any employer, if you don't feel you have the expertise, you need to hire people who do have the expertise, and there's a lot of companies you're still ultimately responsible, but companies you can outsource with. You maybe outsource with a company that knows what they're doing. If you don't. And I think you're right. I think a lot of small companies, it may not be economically efficient for them to really have all the staffing and all the things that they need. It may be that they need to outsource that. Going back to the person who's thinking about whistleblowing, obviously people, you worry about your job. A whistleblower is a person. It takes a certain particular amount of courage to do that. Unfortunately, those people who will actually step forward and be a whistleblower are more few and far between. I mean, I get so many employment cases in so many contexts where people, they get terminated, but they never complained before they got terminated because they were afraid they were going to get terminated. I mean, there are laws to protect people who get terminated for whistleblowing, but that's obviously, I realize, not a lot of consolation when you're looking at, am I going to lose my job and have to make the next month's mortgage payment or car payment or whatever, or am I going to be blackballed in the industry? I mean, one of the things for Mr. Marcus was, to bring this forward and to be a whistleblower in this area. It was a big risk for him, and it takes a lot of courage for a person to do that. I think when we're dealing with national security and the things that we're dealing with, these things are just too important to stand on the sideline and not come forward. Obviously, try to work within your company to try to get them to do the right thing. But, unfortunately, a lot of times people just aren't going to do the right thing. In our case, Mr. Marcus went to Aerojet, I think, knowing that, there were people that were trying to improve the cybersecurity. He went there with that goal. He didn't go there like first day to find problems and become a whistleblower. But, when you get to the point where you feel that your recommendations and the things you're trying to do aren't going to happen, then you reach a certain, sort of frustration level where, you have a whistleblower has to take a different path.
Absolutely. Greg, I love talking with you. I think I could talk with you for like hours on end. And I know I owe you definitely a glass of your favorite libation. The next time I see you in face to face, I want to thank you for the kind allotment of time. And I want to foot stomp the entire audience that if they have ever a question, concern, thought around any of these topics, I can't think of one person that has more education and more importantly, experience in this situation than you right now. And I think they need to reach out to you as quick as possible. You have been through not only the laws at the federal level, you're also in the state of California. You also understand deeply the whole prime contracting attributes of things. And I know that you have great access to resources around you. And I think you're just a great American. So it's wonderful to be promoting you and your business. I want to thank you very much for coming on board.
Well, thank you for having me.
Thank you, Carl and Gregory, for that informative Q&A session. It is important for contractors to understand the risk of noncompliance as they bid DoD contracts with cyber requirements. Sitting back to wait for the government to take action for your noncompliance may not be your only concern, as evidenced in the Aerojet Rocketdyne case.